Good afternoon, Your Honors.
Afternoon.
Hear ye, hear ye, hear ye. The court of the 14th District Texas now in session. Pursuant to adjournment, God save the Constitution and the honorable court.
Good afternoon, everybody, and welcome to the 14th Court of Appeals and today's Zoom oral argument. I am Justice Kevin Jewell, and with me on the panel is Justice Tracy Christopher and Justice Meg Poisson. Ordinarily, Justice Christopher would be presiding over today's argument, but she is in a remote location off-site, and in the event we have any technical difficulties and we lose Justice Christopher, then Justice Poisson and I will press on, and Justice Christopher can watch the arguments at a later date, and all three of us will participate in the decision. We have one case on the docket today, and it's number 19922 Civil, 4922 Holdings LLC and others versus Salvador Rivera. Could I have announcements from counsel for the appellant first?
Good afternoon, Your Honor. Lisa Norman from Andrews Myers on behalf of appellants Horizon and 4922 Holdings.
And we have 15 minutes per side. And do you want to reserve time for rebuttal?
Yes, I'll reserve 5 minutes for rebuttal.
Okay. And counsel for the appellee?
Derek Obialo for the appellee and cross appellant, Jose Salvador Rivera.
Okay, thank you, sir. The court is ready to hear arguments. And Ms. Norman, we can start when you're ready.
Thank you. May it please the court. This case arises from a construction contract for which the appellee, Rivera, was hired to perform work at the Joy Tabernacle Church for the appellants, Horizon and 4922 Holdings. I'll be referring to the appellants today jointly as Horizon. Today I'm going to address 4 points. First of all, at a minimum, the judgment should be reversed because the evidence is legally and factually insufficient to support Rivera's damages. Mr. Rivera pled the doctrine of substantial completion or substantial performance, under which his damages were required to be calculated by subtracting the cost to complete and repair the work from the balance of the contract. When you do the math based upon the number.
Excuse me, I thought that he actually did not plead that and that you objected to a trial amendment on that point.
We initially objected to a trial amendment. Thereafter, after a break, the parties stipulated on the record that he could amend his pleadings, and we actually stipulated to the fact that he had substantially completed.
Mm-hmm. And did he ever amend his pleadings?
No, the parties just entered into a stipulation that he had substantially completed. Because he asserted that he had substantially completed his work, he was then required to calculate his damages based upon subtracting the cost to complete from the balance of the contract. And the undisputed facts in the case regarding the balance of the contract and the cost to complete and repair show that when you do that calculation, it is actually a negative number. Therefore, Mr. Rivera would not be entitled to any damages.
But can I interrupt you there, counsel, real quick? Couldn't the jury have discounted your evidence regarding the cost to remedy?
Theoretically, yes, but then he would have, under the doctrine of substantial performance, he was required to put on evidence of the reasonable and necessary cost to complete and repair. He did not put on any legally or factually sufficient evidence of that and did not controvert at all the evidence that was put on by our expert.
But if your expert spoke on that topic, couldn't the jury have accepted what it wanted to from that expert and then rejected the rest of it and then arrived at the damage figure that it did?
It certainly could have. Here, Mr. Rivera on cross-examination agreed with and actually did not dispute the majority of the damages that were asserted. The only evidence in the record with regard to the cost to complete and repair the damages was submitted by Mr. Jones on behalf of Horizon and 4922 Holdings. Mr. Rivera, after asserting the doctrine of substantial performance, in order to recover damages, would have had to put on evidence of what it costs to complete and repair. He did not do so, so the only thing the jury had was the uncontroverted evidence that was presented by Mr. Jones. Second, the judgment should be reversed because Mr. Rivera actually admitted at trial that he did not complete his scope of work, which was a condition precedent to Horizon's obligation to pay. Thus, because Rivera admitted that he didn't complete his scope of work, thereby materially breaching the contract, Horizon's obligation to pay the retainage and the balance was excused.
So
And
let me ask you a question on that. What items exactly did Mr. Rivera not complete?
No problem. One moment.
And didn't you tell him to stop working? So how was he going to be able to complete his work?
No, we did not tell him to stop working. In fact, it wasn't until the briefs in this case that there was ever an allegation that we terminated him or asked him to stop working. In fact, we asked Mr. Rivera to complete his work, and they took the position that they had, in fact, completed the work when the evidence then on cross-examination showed that they had not.
Who testified to that on your behalf?
That he had not completed the work?
Yes.
It was Mr. Rivera and his son, both. There were multiple pieces of the scope that were not completed. The main one that they both of the Rivera, the father and son, agreed they did not complete was the stage and the stage stairs. Photographs of those were shown at trial, and they admitted they had not done those. In the record at volume 2, starting at page 47 and going to page 83, and these are actually cited in our brief on page 4, the unperformed work that Mr. Rivera agreed on cross-examination he had not completed were replacing the doors, performing the exterior painting, completing the stage, providing the plans for the stage, and obtaining the inspections. All of these tasks were included in his scope of work and were required to be performed before Horizon was obligated to pay him for those items. So because he admitted that he did not complete his scope of work, Horizon's obligation to pay him for those items is excused. And the judgment should be reversed because he admitted that he did not complete his scope of work. Third, because Mr. Rivera breached the contract first, the trial court erred by failing to grant Horizon's motion for judgment notwithstanding the verdict regarding the prior material breach defense. The legally and factually sufficient evidence proved that Mr. Rivera breached first by not completing his scope of work, thus entitling Horizon to recover on its breach of contract claim. In fact, both Horizon and Rivera were asserting competing breach of contract claims. The jury found that both parties breached. However, the evidence is clear because he did not finish his scope of work and our obligation to pay was not triggered until he did so. His failure to complete his scope of work renders him the first breaching party.
Why couldn't the jury have determined that the items that you mentioned that were incompleted or that were incomplete were not material?
Were not material to completing the
Couldn't the
project?
jury have determined those items were not material and therefore did not constitute a material breach of the agreement?
No, I don't believe that was in the jury's purview. What the jury had and what was whether or not he complied with his contract. And he
Right, but I think the jury questions though incorporate the elements, or the jury was instructed that a failure to comply must be material, and they were given instructions on what circumstances to consider and whether or not a failure to comply was material. And so could they not have determined that some or all of the items that you mentioned were in fact not material?
Not based upon the contractual provisions that the parties agreed to and were presented at trial and the testimony of the Riveras. The contract itself, which is contained within Appendix 1, sets forth that in order for him to get paid, he has to complete his entire scope of work. And so because here what he was seeking to get paid for were items that he had in fact not completed, it would be material for him to have not done the work that he's asking to be paid for. And specifically in Article 5B of the contract, which again is in Appendix 1 to our brief, the contract only requires payment for work actually performed. And so it would be material whether or not he actually performed the work. And he admitted he did not perform the work. And since the condition to proceeding to getting paid for the work is doing it, and he admitted he didn't do it, Horizon's obligation to pay was never triggered, and thus any alleged breach would be excused. Additionally, the contract in Article 5F, which again is in Appendix 1, shows that Horizon can withhold funds necessary to complete the work. And since he admitted he didn't complete the work, Horizon put on evidence of what it cost to complete that work. And that cost was greater than the balance that was left on the contract. There was $15,900 on the contract. The cost to complete and repair was $49,750. So there was actually a negative contract balance of $33,850. The jury charge actually instructed the jury on the specific math formula they were to do, and they disregarded that formula.
Can I ask you one quick question on the remediation? Has Horizon actually paid anything to have any remedial work done?
Yes, Horizon incurred the cost to remediate it and presented that in a detailed spreadsheet that was gone through with Mr. Jones line by line during the testimony at trial. So those costs were
those were costs that had actually been incurred and not estimates of what was possible.
That is correct. They actually incurred the cost. They actually completed the work and hired whomever was necessary in addition to providing that work themselves. And so those were the detailed costs that were provided as to the cost to complete.
Well, your time's up on opening, and so we'll hear from you in rebuttal. And at this time, we'll hear from the appellee.
Thank you very much.
Thank you.
May it please the court. I'm here today to, first of all, Your Honors, I'm going to maybe address some of the questions that you have posed to opposing counsel. In the costs, first of all, Justice Jewell, the costs that were presented at trial were estimates, not actuals. So at the time of trial, they may have completed it now, but at the time of trial, it was still estimates. That's just by the way. And yes, the jury could have determined materiality of breach. Justice Jewell, I think you are right. That was part of what the jury was supposed to determine, whether breach is material or not. And Justice Christopher, I think you asked whether we were we were told to stop work. Yes, we were. And that's part of the evidence. Now, this case is one where they are competing facts at trial. There were testimony from our side, from Mr. Rivera, specifically saying, and this was uncontroverted testimony, that he was told to stop work when he was doing the exterior painting. After he was told to stop work, nobody told him to come back and finish up the work, and all the way until today. And he was told to stop the work by Bill Roby, who was the superintendent of the project. Now, the Horizon wants to argue that this is a substantial performance case. This is not a substantial performance case. First of all, the stipulation that was done at the close of evidence. You were right, Justice Christopher, that we attempted to make a trial amendment. Counsel opposed it. The judge denied our amendment, and we proceeded on a breach of contract case all the way until the end, when the case was about to be submitted to the jury. That's when counsel, and this is all in the transcript before you, that's when counsel stipulated that we substantially completed the contract. So this is a breach of contract case. When you look at the jury questions and the answers that the jury gave to those questions, they determined that Horizon breached the contract first, and their breach was material. In order to get to substantial performance, the party who is seeking substantial performance has to be the one that is in breach of contract. Then, as a substitute, or as an alternative, he gets to plead substantial performance. But if the court or the jury never gets to the second level, which is, did you breach the contract? Yes, I breached it. Then did you substantially perform? Then now we can start discussing substantial performance. But in this particular case, the jury determined that Horizon breached the contract first, and this breach was material. So we don't even get to the question whether there was a substantial performance or not. And the stipulation that counsel made at the end of trial didn't have anything to do with all the causes of action that we have pled. This case depended on a breach of contract theory and quantum merit and foreclosure of lien. And both cases, I think the jury answered in the affirmative for Rivera.
Can I interrupt you real quick, Counselor, with a quick question on the items that Horizon says your clients did not complete? Did your clients ever offer to finish the stage and the stairs and replacing the doors and those things that Horizon's counsel says were not completed?
No, so we disputed that those items were uncompleted. In fact, the evidence from our end, which one of the key evidence was a attachment as an appendix, Plaintiff's Exhibit 3 at trial. That showed the final invoice. In that invoice, it included all the scope of work in this contract, all $139,000 of the contract. And in each particular line item, it says 100% completed. And I went down the whole list and I asked Mr. Rivera, did he complete every one of them? And he said yes. And by the way, the project manager for this project, who is Horizon's employee, David Pratt, approved that invoice. He revised it and he approved it, including the bonus of $5,000 if we complete in 4 weeks. And the evidence showed that we completed it in 2 weeks, and he approved that evidence, that bonus. So the only evidence and in this case, from our perspective, our theory of the case, was that the exterior painting part of the work was the one that was not completed. And that's the only thing that we admitted that was incomplete in this project.
And you completed the block filler work?
So Your Honor, the block filler is outside the scope of this contract, and I hope I'll get to it. And that's why we have a claim for foreclosure of lien. We think this case, we should have gotten $17,000 in damages rather than the $3,008 the judge awarded. Because the block filler, what Horizon argued was that since we did not have a written change order, which the contract stipulated, that you have to have a written change order in order to change any scope. Block filler was outside the contract. We couldn't claim it as a contract damage. So we claimed it as a quantum merit case. And that's how we got the block filler recovery as part of our foreclosure of lien.
Oh, so are you agreeing that the block filler was outside the scope of the contract?
Yes, we did agree that the block filler was outside of the scope of the contract because there was no written authorization for it. So what happened with the block filler was after we were told to stop work, which was around February 16 of 2016, they called us back to come and do block filler work, and which was in April of the same year. And so we came back and we did block filler. There were competing evidence from our expert and their expert whether block filler was part of the exterior painting. Their argument was from their expert that block filler was part of the exterior painting. And that's somewhat illogical because if it was part of exterior painting, then there was written authorization for it. So they had a conflicting argument with the block filler. In any case, we admitted the block filler was outside of the scope. Our expert says that the block filler is totally different from the exterior painting. And we did that outside of the scope of this contract, and we're entitled to claim for it as a quantum merit claim. So this case rises and falls on a breach of contract claim, not substantial performance. Even if in the alternative, it was to be a substantial performance. I think Justice Jewell, your question is very trite, because the jury could have discounted that reasonable and necessary evidence that opposing counsel argues on. The jury could have discounted the evidence of their expert, which under cross-examination were able to show that that he lacked credibility. So the jury, yes, could have discounted that. Particularly in the this case, when you talk about substantial performance, you have to the standard there is that the incomplete work will be remediable. In our case, the only incomplete work that we have alleged and which the jury found was the exterior painting. They do not want us to do exterior painting. So exterior painting was never necessary. In fact, under their argument, they replaced exterior painting with block filling. So they can't say that exterior painting is reasonable and necessary. It's not necessary. So what this comes down to is that this was a removal of scope rather than a substantial performance where you have to put on evidence of reasonable and necessary remediation. I know that they have asserted that there were several scopes that we did not complete. We presented opposing evidence to show that we indeed completed those. And the jury had to make a determination of whose evidence they believed. And they believed ours and rendered judgment for us.
Now, in the trial court, you asked for both the $3,800 and the $17,000. On appeal, are you just asking that on your cross point that you get the $17,000?
No, in the trial court, we did not ask for the 38. We asked for the $21,000.
Right,
when
the 38 from the breach of contract damages plus the lien amount, right?
Right. So what the jury did, the jury split the baby. They gave us 38 for breach of contract and then 17 for the lien foreclosure case. Our cross appeal says that because the lien foreclosure by necessity includes the contract damages plus quantum merit, that's what the judge should have entered judgment for, not just for the contract damages of $3,000. And that's our cross appeal. Plus
okay. The contract damages were $3,800 and you didn't get a quantum merit finding.
We did. So if you look at the jury question, it says, what amount do you award Rivera for materials and labor that we are unpaid for, which obviously includes the contract plus the work that was done outside of the contract, which the jury answered it was $17,000.
Some of that is overlapping though, because the retainage, the 13.9 in retainage is part of the contract damages. And the jury gave less than that as part of the contract damages, correct?
I totally agree with you. That was the difficulty that we had with the jury answers. I think when you add those two damages, they equal 21.6, which is what we were asking for. I believe they wanted to give us 21.6, but they kind of like tried to split the baby, and then it came out to be somewhat uneven. But I believe the right thing to do that the judge should have done was to go with the larger amount, which of course encompasses the contract damage plus our quantum merit damage. And the judge did not. He discounted what the jury says we are supposed to be entitled to. Now, if I may just touch on that, we are also requesting for prompt pay interest rate of 18%. the judge never entered judgment for it. Under statute, we were entitled to it. That question was posed to the jury. The jury answered in the affirmative, but the judge denied to give it to us without any explanation.
So the dollar amount of the $17,000 in damages the jury found, that was based on a finding that your lien was not in bad faith?
That's correct. That the lien,
Okay.
that the lien.
But there wasn't actually a liability question associated with that dollar amount, was there?
The question there says, what amount represents the labor and material that Rivera rendered in this project that was unpaid? And that's how they answered it, 17,000.
Right, but that question, you're referring to question number 8, and that question was predicated on the lien question, question number 7.
Yes, Your Honor. Mm-hmm. Yeah, it was. And the question number 7 asked if the lien represented the actual amount that we were owed. And they answered that in the affirmative. I believe if you are right with regards to substantial performance, what should have happened in this case, if truly this case depended on substantial performance, and the opposing counsel's argument was right, what they should have done was, after we rested as plaintiffs, they would have asked for a directed verdict, thereby precluding putting on their own evidence of reasonable and necessary. But they went ahead and submitted that evidence. Then it doesn't matter who the evidence, which party the evidence comes from, as long as that evidence is presented before the jury. And the jury, as a trier of fact, has the duty to determine what amount of weight or depending on the credibility of the witness, to give that that amount that the expert proposes. So, however, this case, not substantial performance, is purely breach of contract, and the questions are very direct that it is breach of contract. And I believe, I see my time is up. If I may just make this one point, Your Honor, I know I did not talk about how our breach was subsequent to the defendant's breach. But that's there in my brief, and that's because we did not go back to perform the exterior painting work. But you can see that the exterior painting work was only required to be done after they had already breached, with the jury determined that they breached the order.
All right, thank you, counsel.
Thank you.
And we'll hear from appellant's counsel on rebuttal now.
Sure.
Can you see me now?
Yeah.
Thank you very much. Very quickly, first, to address a couple of points from Mr. Rivera's counsel. The evidence at trial showed that the invoice was not approved. It was stamped received, and Horizon never approved the amounts that Mr. Obialo just said were approved. Additionally, the bonus was not approved because it was required that the work be completed in 4 weeks. And they admitted that the additional $5,000 bonus was not available because they didn't complete the work in 4 weeks. The block filler, it was testified at trial, was not outside the scope. It was actually part of the painting scope of work. Very quickly, with regard to the cross appeal, the entire cross appeal itself, as we asserted in our reply brief, was untimely. The brief itself was actually due on March 25th, while Horizon requested and was granted an extension to file their brief. Rivera's counsel never requested an extension of time to file, and so they didn't file until April 13th, which was 3 weeks after their brief was due. So their entire cross appeal is untimely. Let me address real quick the substantial performance issue. Mr. Rivera's counsel confuses the nature of the substantial performance doctrine and misconstrues the jury's findings. Substantial performance is not, as he would seem to argue, a standalone alternative cause of action. Rather, when the parties either are asserting that the contract has been substantially performed, the required measure of damages for that breach of contract claim then becomes the cost to complete and repair minus the balance of the contract. And so he asserted that he had substantially performed. We agreed that he had substantially performed. So the measure of damages for his breach of contract claim is dictated by the Texas Supreme Court in the Vance versus My Apartment Steakhouse of San Antonio case from 1984. And it holds that a substantially performing contractor's measure of damages on their breach of contract claim is the contract balance less the remedial costs, and notes that this substantial performance doctrine, which is not a requirement to be pled, but here was actually an agreed stipulation. It allows the breaching parties who have substantially completed to recover on a contract. And so it's not a separate cause of action. In the event that he prevailed on his breach of contract claim, that was the measure of damages. And so even if you accept the jury's finding that he breached second, which we disagree with, when you apply the Vance formula that the Texas Supreme Court dictates, his damages are zero because it's actually a negative $33,850. With regard to the prompt pay interest, the trial court did not err by failing to award prompt pay interest because Rivera never actually moved for entry of that award, nor did he object when prompt pay interest was not awarded. The judgment that was entered by the court included the 5.5% interest from the finance code or government code, but he never objected to it and never actually moved to enter for prompt pay interest. So that argument is waived. And with regard to the $17,775, I believe that you hit the nail on the head exactly, Your Honor. There was no quantum merit question. There were only two damages questions submitted, the breach of contract and then a lien claim, but they were not submitted as alternative, or the two damages questions that were submitted were not alternative questions from which he could just choose the larger recovery. The permissible—
Why not? Why not? Why couldn't he choose the larger recovery under the second damage question?
Because the permissible amount of a lien claim is governed by proof of the debt and proof of performance of the contract. And the San Antonio Credit Union versus O'Connor case that we cited sets forth that standard. Here, because what has to be taken into account are the various conditions that have to be met on the contract. Rivera's lien affidavit actually acknowledged this principle by referencing the contract with regard to the services he had to perform. And so it follows that the value of his lien claim cannot exceed the amount that would be recoverable under the contract. The contract contained many conditions on his right to recovery, and he acknowledged failing to meet all of these conditions. And so the jury only awarded the $3,875 on the breach of contract. By awarding Rivera the $17,775, which is an amount greatly exceeding his contractual damages, would have been legally inconsistent with the breach of contract damages that were awarded. So the trial court correctly disregarded that $17,775. And in fact, in that San Antonio Credit Union case, they noted that a jury question on the lien value was not actually even necessary when the jury makes a finding on a contractual debt owed. And so here, arguably, the jury question that was submitted on the lien claim wouldn't have even been necessary, since the finding always hinged on what they found on the contract. However, that brings you back to the fact that they're not entitled to recover on the contract since they failed to perform.
All right, thank you, counsel. Any further questions? All right. All right. We thank both lawyers for the presentations. The argument's very helpful, and the case is submitted and you are excused.
Thank you very much, Your Honors.
Thank you, Your Honor.